Hey everybody, Josh Sheridan here this week. Wanted to talk to you about what to do if you've been served papers for divorce or for paternity. So many people have maybe seen in the movies or on TV, my wife served me with papers, my husband served me with papers, and we understand in a general sense that means, but what does it actually mean, especially here in the Tampa Bay area, Florida, as it relates to family law? Well, generally in Florida, there's going to be one of two types of cases where you're quote-unquote served papers, and that's either going to be a divorce or that's going to be a paternity action. Now, there are other types of cases, but usually if it's an initial action, not a post-judgment modification or enforcement action, but an initial proceeding, meaning there hasn't been a court case before these papers were filed, you're looking at a divorce or a paternity action. So right off the bat, the first thing that you need to do is look at the summons that you were served and see that you have 20 days to file an answer from the date that you were served. So you look at the date on the summons, what date does it say you were served? You've got 20 days to file an answer with the clerk. Now you can do that on your own. I don't advise it. People can pull their teeth on their own, but I advise that they go get a dentist. So same thing with a lawyer. If you've been served with paperwork, you've got 20 days to file an answer. You should probably consult an attorney. The next thing is you have 45 days, no matter whether you're the petitioner or the respondent in an action, from the date that somebody's been served to file your mandatory disclosure documents. Now, in Florida, we have Rule 12.285, which discusses what documents need to be produced by each party in a divorce to each other. These things, again, if you watch my discovery video, are financial affidavits, tax returns, bank statements, retirement statements, pay stubs, deeds for real property, lease agreements, applications for credit, all that sort of thing. So that needs to be exchanged between the parties. And then generally, before the parties can get in front of a judge, either on a temporary relief hearing or for a trial, the parties need to go to a mediation. Now, oftentimes I hear clients say, I don't want to go to a mediation, there's no way we're coming up with an agreement. It's important that you understand that the courts require you to go to mediation before you can even get in front of a judge. So whether or not you want to be at mediation, you need to go to mediation if you don't have a deal, so that you can take the next step, which is either seek temporary relief from the court or get the matter set for a trial. So from a timeline perspective, you'll start to see how this works out. You need the discovery done before you can go to mediation, because at mediation you need to know what the numbers are that you're dealing with to be able to have a meaningful attempt at resolution. So that's why 45 days from date of service to get discovery done. Try and get that mediation scheduled as quickly as possible thereafter, so you don't have any dead air in the case. And then at mediation, there's a couple ways that can resolve itself. You can have a global settlement, you can have a partial settlement, you can have a temporary settlement, you can actually continue your mediation, or you can have what we call an impasse. And so what an impasse is the parties could reach an agreement. And usually at that point, either motions are being scheduled for a hearing before the court or a trial's being set. But this is just a really quick overview of what you're dealing with when you're getting served. But if you take nothing else away from this video, it's if you get served, you should probably call an attorney. If you don't know a family law attorney, I know a good one. Give us a call. We'll help you out. Thank you, guys.